Section 75 subsection 4 is a very important section. We file writ petitions. This question is a very important and pertinent question of law. Section 75 subsection 4 says an opportunity of hearing shall is a very important word under law. Whether adverse decision is contemplated or not, the assessee will not know at the time of presenting his case. Reasonableness of opportunity and ex parte orders are not permissible, violating the principles of natural justice. That is, in this case, that is Patna High Court judgment. Next important thing to be understood with respect to the principles of natural justice is denial of procedural fairness. Principles of natural justice is a basic jurisprudence that need to be followed by any department or even by the state under Article 12. Very important. Personal hearings are indispensable. The word indispensable is used as part of the judgment. My dear friends, under the GST Act 2017, Section 75 subsection 4 is a very important section. Recently, the department, that is both CGST as well as SGST, in most of the demand orders, when they issue demand orders, opportunity of being heard is not provided. So many of the clients, when they come questioning on this aspect, and whenever we file writ petitions, this question is a very important and pertinent question of law. Because as per section 75 subsection 4, for the benefit of the listeners, it is very important to understand section 75 subsection 4 clearly provides that an opportunity of hearing shall be granted where a request is received in writing from the person chargeable with tax or penalty, where any adverse decision is contemplated against such person, the proper officer shall, if sufficient cause is shown by the person charged with tax, grant time to the said person, adjourn the hearing for reasons to be recorded in writing. The very important point to be noted here is section 75 subsection 4. For the benefit of the listeners, I'll read it one more time. Section 75 subsection 4 says an opportunity of hearing shall is a very important word under law, in any law for that matter, which is a mandatory aspect in any provision. Shall be granted where a request is received in writing from the person chargeable with tax. So it mandates to say only when there is a request in writing, opportunity of personal hearing can be granted. That is, opportunity of being heard can be granted, or penalty, or where any adverse decision is contemplated against such person. So in all the cases where there is an imposition of tax or penalty or interest or any adverse decision is contemplated against such person, then opportunity of being heard has to be provided. The question here is whether adverse decision is contemplated or not, the assessee will not know at the time of presenting his case. It is the decision of the department. In that situation, how will the assessee know whether to request for a personal hearing, that is opportunity of being heard, when he is not able to understand whether you are contemplating to issue a adverse decision or an order? Considering this fact, the Supreme Court judgment, even in the erstwhile section 75 subsection 4 of the CGST Act as well as SGST Act provides for an opportunity for personal hearing in two key scenarios. One, when the person chargeable with tax or penalty submits a written request for personal hearing, that is opportunity of being heard. Two, when an adverse decision is being contemplated against the person, then opportunity of being heard can be provided. It only covers two situations. Then the question here is whether the department, that is GST department, can pass an order of determination of tax without providing any opportunity of being heard is the question. The answer is complete no, because the requirements reflects a long-standing principle, that is principles of natural justice upheld in other taxation statutes such as Customs Act 1962 and erstwhile Central Excise and Service Tax Law. The obligation to offer a personal hearing is essential to fairness, has been reaffirmed by the Supreme Court in important case Fedco Private Limited versus S.N. Bilgrami 1999 110 ELT 92. This is the citation of the case. My dear friends, not only that, reasonableness of opportunity and ex parte orders are not permissible. Very important, ex parte orders are not permissible. Considering that fact, reasonableness of the opportunity has to be provided. In fact, the High Court of Patna in Amna Parveen versus State of Bihar 2021 51 GST L 225 Patna highlighted two fundamental violations in case of ex parte assessment, that is, lack of sufficient time for the petitioner to present their case, violating the principles of natural justice. That is, in this case, that is Patna High Court judgment, they clearly said that if there is no adequate time limit provided for replying, that is also a violation of the principles of natural justice. 2. An assessment order devoid of adequate reasoning, failing to justify the determination of the amount payable by the assessee, is also violation of the principles of natural justice. My dear friends, the court also held that such violations entailing significant civil consequences necessitate judicial intervention despite the availability of statutory remedies. Next important thing to be understood with respect to the principles of natural justice is denial of procedural fairness. In this case, similarly in case of Ben Catering and Allied Services Private Limited versus Assistant Commissioner 2021 TMI 772 APHC, the Andhra Pradesh High Court underscored the principle that when a procedure is prescribed by law, it must be followed strictly. In this case, the denial of a personal hearing prejudiced the assessee, impairing their ability to address intricate issues of fact and law effectively. The court set aside the impugned order, remanding the matter for fresh consideration with a mandated personal hearing. My dear friends, this is a landmark judgment from Andhra Pradesh High Court because not giving an opportunity of personal hearing amounts to violating principles of natural justice certain times under the GST, because determination of tax may lead to section 73 or section 74 proceedings. If it leads to section 74, then very important point to be noted is procedure prescribed by law has to be followed. Even for 73 it is important, but it is even more significantly important for section 74 because it may amount to demand order under section 74. So considering this, the importance of personal hearing has been re-established, or rather reiterated or upheld as part of this Andhra Pradesh High Court judgment. Adding to the importance of personal hearing, we all know personal hearing is not merely a procedural formality, but a substantive right. Very important point to be noted. Personal hearing is a substantive right enabling the assessee to engage with the adjudicating authority. Why is a personal hearing opportunity provided? Not just for the principles of natural justice, but for the purpose of engaging with the adjudicating authority to explain your case, to explain the law, explain the position of law, and see to that your reply is taken into consideration by the department. Any reply that you provide has to be taken into consideration by the department, and even if they don't consider a reply, the reason for not considering a reply has to be provided. This establishes the principles of natural justice. Considering this fact, in Automotive Tire Manufacturer Association versus Designated Authority 2011 ELT Supreme Court judgment, the Supreme Court emphasized, very important, the apex court of our country, Supreme Court emphasized that hearings allow authorities to clarify doubts, assess the demeanor of witness, providing a platform for fair resolution. If this is the importance that the Supreme Court has provided for the principles of natural justice with respect to assessment or determination of tax, then section 75 subsection 4 is a mandatory provision, even if it is not requested for. Providing for personal hearing is a mandatory thing as per the Supreme Court judgment. And very important, my dear friends, adhering to the procedural standards, because when a personal hearing has been provided as a mandate, that mandate is followed up by a request in writing. Anyway, when it is mandated, certain times the assessee under the GST will not even know there is an opportunity of personal hearing. In that case, it is also the duty of the department to say in their notices, if in case, if you may need personal hearing, you can request in writing, maybe one of the line they can add as part of their notices. In the absence of which, anyway the assessee can ask, but the question here is, what if the assessee doesn't record his request for personal hearing in writing? Whether orders can be passed disregarding it? The answer is no, because principles of natural justice is basic jurisprudence followed as part of the taxing statute around the world. Not just GST indirect taxes, but also income tax, even under the various economic laws. Principles of natural justice is a basic jurisprudence that need to be followed by any department or even by the state under Article 12 of the Constitution of India. The next important point to be noted, there are some key judicial pronouncements supporting natural justice. My dear friends, opportunity of hearing in quasi-judicial procedure is mandatory. Supreme Court in Assistant Collector of Customs versus Charandas Malhotra 1983 13 ELT 1477 Supreme Court judgment ruled that, very important, ruled that personal hearings are indispensable. Very important, personal hearings are indispensable. The word indispensable is used as part of the judgment in quasi-judicial proceedings, especially when decisions affect substantive rights. Why is a personal hearing is mandated as part of quasi-judicial proceeding? Is that because when a substantial right is affected, in case of assessee under the GST, the consequence of passing an order could be an attachment of his bank account, could be a recovery procedure, or certain times the business may come even to a closure. It may be fatal for an assessee. In that case, if an order is passed without considering the aspect of personal hearing or without following the principles of natural justice, then it may certain times be even affecting Article 13. In consequence of that, it may even affect Part 3 of the Constitution of India, that is fundamental right, leading to affecting Article 19(1)G, affecting the freedom to carry on business or profession. So considering this fact, it is very, very important that the principles of natural justice has to be followed as part of the taxing, as part of the taxing statute. My dear friends, ex parte orders and procedural fairness is also a matter dealt by IPC Packaging Company Private Limited versus Additional Commissioner of Customs, ICD Bangalore 2017 Karnataka judgment. The Karnataka High Court invalidated an ex parte order where the adjudicating authority failed to provide adequate notice and improperly served hearing notices. And very, very important, my dear friends, timing of hearing and reasonable opportunity. Madras High Court in its landmark judgment, Kavarlal and Co. versus Joint DGFT, Chennai 2019 368 ELT 876 Madras, deemed 48 hours for responding to a show cause notice as inadequate, emphasizing that fairness demands reasonable time to respond. It is very important. It is just not providing an opportunity. The question here is whether the time provided for responding is adequate with respect to representation. So you may not issue a notice today and call for a physical hearing or a personal hearing tomorrow. There should be an adequate time provided, and the time has to be to ensure, the time is provided to ensure the principles of natural justice is followed. My dear friends, to conclude, very, very important principle that is established under section 75 subsection 4, even though the phrase is the personal hearing has to be requested by the assessee, the spirit of that phrase as part of section 75 subsection 4, still it is the duty of the department to provide personal hearing for the assessee. My dear friends, the principles of natural justice, including right to a personal hearing and recent decisions, are integral part of maintaining transparency and fairness in GST administration. Judicial interpretations reaffirms the necessity of providing adequate notice, reasonable time for responses, adhering strictly to procedural mandates. Third, offering a genuine opportunity. Very important. Offering a genuine opportunity for personal hearings, especially in complex cases involving intricate legal and factual issues. By embedding these principles within the GST framework, tax authorities can enhance procedural integrity, fostering taxpayer confidence and promoting a fair tax administration system. Unfortunately, most of the orders passed by the department in the GST law, that is the GST department orders, lack fairness. 2, they don't provide opportunity of being heard to the assessee while they determine the tax or while they impose the penalty or interest as the case may be, and it becomes fatal to the assessee. Most of the time, the assessee has to approach the constitutional court, that is the High Court, through Article 226 through writ petition. And through writ petition, when this matter is raised, when the directions are sought, until the time the GST tribunal is established, it is a hardship for the assessee. Considering all these factors, it is the responsibility of the department, that is the GST department, CGST or SGST as the case may be, to provide adequate opportunity to the assessee to represent his case and pass and adjudicate the order, because when it is a quasi-judicial proceeding, principles of natural justice is embedded as part of the proceeding. However, section 75 subsection 4, provides and mandates personal hearing when an assessee requests in writing. And the very important challenge of the assessee, how can assessee know that the officer is contemplating to pass an adverse order unless he meets the adjudicating authority or he participates himself in the quasi-judicial proceeding? How can he or she, the assessee, can contemplate what adverse orders the department may pass? This is a big question of law. In the days to come, principles of natural justice will definitely be questioned in the apex court, not just for the orders that the GST department is passing now, but most of the orders might become unconstitutional, unlawful, and illegal if the orders are not following principles of natural justice embedded as part of section 75 subsection 4. That is the spirit of the GST law. That is fairness of tax administration, principles of natural justice, and adequate opportunity of being heard with adequate time. Thank you.